Ladies and Lords, we have copies of Lumber. I realise they haven't been hole punched, but would you like me to arrange them to be hole punched and then handed up, or to be handed up?
If you could, please, yes. I don't think we need them now this minute, so that can be done. Thank you.
So, ladies and Lords, the second ground of appeal concerns the judge's findings in relation to same interest in the membership of the class. As the court is aware, this depends on the representative action procedure, which is now to be found in CPR 19.6, which is in the bundle, authorities bundle 1, tab 2. There's the relevant extract from the white book. The rule in question is at page 657. Where more than one person has the same interest in a claim, the claim may be begun, or the court may alter the claim be continued by or against one or more of the persons who have the same interest as representatives of any other persons who have that interest. And then there's various provisions as to directions that may be given. We submitted before the judge, as is recorded in paragraph 85 of his judgment, that the following propositions applied. Firstly, that persons have the same interest if they have a common interest and a common grievance. Secondly, that persons may have the same interest in the claim even if there are disagreements between them, and although this doesn't apply here, even if the quantum of damages suffered is different, they apply. And thirdly, a representative claimant may represent a class even if the members of that class have been affected by the defendant's actions in different ways. We also submitted, and this wasn't disputed, the fourth point that the judge lists at paragraph 85, that there's no limit to the number of persons that can be within the class represented. The judge noted, and there are a number of dicta to this effect in the case law, that, for example, in Bedford and Ellis, the House of Lords described the representative action procedure as a simple rule resting merely on convenience. And 70 years later, Mr. Justice McGarry and John and Rees described the rule as a flexible tool of convenience in the administration of justice. The references for those are page 10 of Bedford and Ellis and page 370E of John and Rees. But where the judge went wrong, we say, is that he wrongly accepted the submission made by Google that a representative action is not available unless every member of the class has suffered the same damage or their share of a readily ascertainable aggregate amount is clear. The judge said at 87 and 88 that there was what he described as a long line of authorities standing for the proposition that damages were not permissible in representative actions, and that the copyright piracy cases where damages were awarded were limited exceptions. Ladies and Lords, we say, first of all, the restrictive view of same interest is not borne out, which may have been found in some of the earlier cases, it is not being borne out in the later case law. In the Irish Rowan, Lord Justice Staunton said that the law had been reformed since the decisions of the early, some of the decisions of the early 20th century. And perhaps the position is if you still have the White Book extracts open, in their discussion of the position in relation to 19.6 over the page at 658, 19.6.3, the editors say, since the Duke of Bedford and Ellis, the interpretation and application of the requirement that those represented should have the same interest has become increasingly liberal. And I'll seek to demonstrate that by reference to some of those authorities shortly. We say that there isn't on analysis, a main principle that representative actions for damages are not permitted. The point is that representative actions for damages are often inappropriate because damage often has to be proved separately, so the claims have individual features. But if they don't have the damages claims don't have individual features, there's no reason why they shouldn't proceed as a representative action. So if claims by members of the class give rise to potential individualised defences, then they won't have the same interest because the damages will be potentially different. But there's no separate requirement that all the members of the class have suffered the same damage. In this case, the representative claimant is in any event claiming the same damage on behalf of each member of the class, namely the uniform sum by way of compensation on either of the bases I outlined this morning. But as I've just said, there's actually no requirement of same damage, only a requirement of same interest. And the test is if the claims don't require individualised treatment, then the same interest criterion is satisfied. The point which overlooked by the judge, and we say by Google in their submissions, is the acceptance that a representative action can be brought in tort. In a tort claim, as opposed to say a claim where all the representative individuals have the same contractual or property rights, it's likely that individuals won't have suffered exactly the same damage. So, if the judge was right that the same interest requirement required the same damage as he says at 86, it's difficult to see how the representative action procedure could apply to tort at all. An interesting example, almost at the end of the cases, but I take you to it now because it really is a very clear illustration of the flexibility of the procedure, is the decision of Mr Justice Aikenhead, as he then was, in Mill Harbour Management and Western Homes, which is to be found in the first bundle of authorities at tab 24. No, it's the wrong way around. It's tab 25. Here, my version of the electronic bundle has them the wrong way around. Actually, Lordship says the same. This case is it's not the most recent, but it's almost the most recent application of the principle of representative actions. But it was relied on by the claimant before the judge as an example of a case in which a representative action for damages was permitted. He doesn't actually deal with it in the judgment. He mentions it only once in passing, but he doesn't consider its effect at all. That case was concerned damages claimed by leaseholders for a development. One of the representative claimants was claiming on behalf of all the leaseholders who'd entered into a contract with the developer. So there was a representative contractual claim, and then there was another representative who was acting on behalf of the subsequent purchasers. So their claims were under the Defective Premises Act. So, in other words, tort claims. Now, Mr Justice Aikenhead considers the authorities, and paragraph 22 summarises there's confusing because there's a long quote and different paragraph numbers in the middle. Yes, 1037, 22. He summarises the principles derived from the authorities relating to CPR 19.6. He points out at point 1 that there must be the same interest. Point 2, which of course we accept, it must be possible to ascertain whether a given person qualifies for membership. Look at point 3, you've got to look at the facts of the case, and point 4, you mustn't prejudge the issues. And then he deals with discretion. Nowhere does he suggest that there's a criterion which requires the same damage. And what's more, in this case, it seems that plainly the same damage should not be suffered. If one looks at paragraph 29, we've got here a case of defective flats, and he points out at 29 that the defendants are saying that the defect will only impact on some of the leaseholders, and the position will be different in relation to different leaseholders. But he deals with it by saying that at 30 that the represented and represented parties have the same interest in the claims for the costs of remedial works. So the fact that the remedial works may be different in some cases is not regarded by him as an objection. And this is a very clear example of a representative action for damages in both contract and tort, where it can't possibly be said that the representative and the represented parties have suffered the same damage in the sense that the judge required. But can I just turn briefly to the authorities? Some of them are historic interest only, but because they've clearly been superseded. But the leading case remains that the decision of the House of Lords in Duke of Bedford and Ellis at tab 11. That was a case of representative action brought by persons who were growers of fruit, flowers, vegetables, roots and herbs within the meaning of the Covent Garden Market Act of 1828. And they were seeking to enforce various rights in the market against the Duke of Bedford, who was the owner of, he still is, I don't know, but who was the owner of the Covent Garden market. And the question was that could that properly proceed as a representative action? And the majority found that it could. The leading speech is given by Lord Macnaghten. Perhaps I could take it up at the bottom of page 7. In the marked passage, in considering whether the representative action is maintainable, you have to consider what's common to the class, not which differentiates the case of individual members. And then the first instance judge who refused the order was influenced by a decision in Temperton and Russell, which is disapproved. And he summarises the position, the next marked passage. The court required the presence of all parties' interest in order that the final end might be made of the controversy. Parties were so numerous you never could come at justice, to use an expression. If everyone interested made a party, the rule was not allowed to stand in the way. Originally a rule of convenience. For the sake of convenience it was relaxed. Given a common interest and a common grievance, a representative suit was in order if the relief sought was in its nature beneficial to all whom the plaintiff proposed to represent. Now, those three criteria are plainly satisfied in this case. There's a common interest, a common grievance, and the relief sought is beneficial to all. Google suggests that there's some distinction drawn between in the speeches between claims for damages and claims for declaratory and injunctive relief. It's true it is that at page 17, Lord Shand makes that distinction, the marked passage 16 to 17, that he's in the minority. He's one of the two dissenting judgments. The majority, made up of Lord Macnaghten, Lord Morris and Lord Brampton, don't make that distinction. Oh, I'm so sorry. Mr. White corrects me. Lord Shand is part of the majority. My fault. He certainly makes that that distinction that I indicated. However, the plurality of the majority, Lord Macnaghten and Lord Morris, don't. So the position here is, we say, is represented by, one looks at the speech of Lord Macnaghten, and who takes the view that this should be a flexible procedure of convenience. Look at what's common to the class, not what differentiates it. It's a simple rule resting on convenience, as he says at page 10. established for the convenient administration of justice. And page 11, he dismisses the objection that the fact that the body of growers is fluctuating and indefinite means that they can't be a representative action. I cannot say I'm much impressed by that difficulty, he says, below the first punch hole. The description is sufficient for practical purposes. Now, again, going forward, just anticipating, the description, it's not said that the description of the class in this case is inexact. There may be practical difficulties in identifying its membership, but that it is not of itself an objection to a representative action. Now, the next case, which I'm not going to go into, if Mr. White seeks to rely on any part of it, I'll deal with it later, but it's marked and Night Steamship Limited. This is a case which has been disapproved on a number of occasions since. Mr. Sarabji, in his article on the background to 19.6, describes it as contrary to authority in a case which has been set back the development of the law for the whole 20th century. But as I'll show you in a moment, in the subsequent cases, it's said on a number of occasions that it shouldn't be followed. The next case that's relied on is a case called David Jones and Corrie, which is available only in two very short reports. Note without a judgment, it's at tab 13. Again, I'm not proposing to say anything about that because one doesn't really know what the reasoning is. It's simply presented in summary. Perhaps the first of the important modern cases is the decision of, more recent cases, is the decision of Mr. Justice Weinrott in Prudential Assurance and Union, which is at tab 15. Perhaps I could begin by referring to the holding. The court had jurisdiction to entertain a representative action brought by a plaintiff suing on behalf of himself and all other members of a class, where each member had a separate cause of action in tort, provided the relief claimed in the representative action could not have the effect it might confer a right of action on a member of the class or bar a defence which might otherwise have been available to the defendant in a separate action. That there was an interest shared by all members of the class represented. It was for the benefit of the class and the plaintiff that the plaintiff be permitted to sue in a representative capacity. For the purpose of condition 3, the court has to be satisfied the issues common to every member of the class were decided after full discovery and in the light of the evidence. So that case is authority for the proposition that a representative action is available in a claim in tort. Paragraph 2, yes, certainly. That holding 2, since the court has to be satisfied the relief claim neither conferred a right not available to a member separate action or bar the defence of the claim, the only relief normally capable of being granted representative action was declaratory relief. No particular instance of injunction might also be obtained. The court had no jurisdiction to award damages. And I certainly accept that that's what Mr. Justice Weinrott says in that case. But things have moved on since then. But the if I take it up at page 251, right at the bottom, letter H, he makes the point, which is summarised in the holding, that no order can be made in favour that would have the effect of conferring a right which wouldn't be available and secondly, there's must be some element common to the claims of all members of the class. But he rejects the submission of Mr. Richard Scott, as he then was, that the court has no jurisdiction in any circumstances to entertain an action by a plaintiff claiming to represent a class in cases where the cause of action of the plaintiff of each member of the class is or is alleged to be a separate cause of action founded on tort. He then deals with the Jones and Corrie brothers case, which I mentioned a moment ago, pointing out that researchers at the Public Record Office have failed to reveal anything but the order of the Court of Appeal. No judgment appears to be available. But he goes on to and then 254G, he summarises the position which is set out in the headline. And I accept, and I just draw the court's attention to it, 256, letter B. It says the court cannot in a representative action make an order for damages. However, 2 years later, in the case of EMI and Riley, Mr. Justice Dillon did just that. Again, it's probably, this is a claim brought by the EMI Records as a member of the BPI. Against it was one of those claims which were at one time very common in relation to piracy. Seems to have faded away with the internet. Pirate records. Brought as a representative action, judgment on admissions is obtained, injunction was granted. That's holding 1, and holding 2. Since nearly all the recordings in this country were produced by members of the BPI, and the defendant had admitted that most of the pirate records had been recordings of discs, wrestles, and tapes made and produced by members of the BPI. The plaintiff, seeing the representative capacity as they claim injunction, could also recover damages. The result of the infringements to the member's copyright, and therefore avoid the necessary complications of establishing damage had been suffered individually by members of the court, required each member to commence proceedings on their own behalf. Now, the judge makes the point that in that case, this is at paragraph 87, the members of the BPI had transferred their rights to the representative claimant, referring to 925 E to D, which is right. I accept that in relation to that case. However, in relation to the other copyright case, which he refers to, Independiente, before the then Vice Chancellor, who was Sir Andrew Morris. Yes, so that's at tab 19. It isn't right to say that in that case the representative claimant has been authorised by the members of the BPI to take action on their behalf. If one looks at beginning at paragraph 9, it's aspiring member has to sign an application form summarising the objects of the BPI and so on. Submitted by counsel for claimant, the operation of the objects clause memorandum of association so on, conferred without more the authority to institute proceedings in the name on behalf of a member. I do not agree. The memorandum confers that the corporate's ability to sue on behalf of others, such acknowledgement does not authorise to institute any particular action on behalf of any particular member. And then at paragraph 16, counsel for the defendants now accepts the representative claimant may sue in a representative capacity without the authority of those he claims to represent, provided only that the claim satisfies the conditions prescribed by 19.6. Accordingly, the relevance of the issue of authority has been reduced, if not extinguished altogether. I do not accept the individual claimant's actual authority from members of either the PPL or the BPI to commence these proceedings on their behalf. And so on. And then the 28, this is a paragraph relied on by the judge, as far as pecuniary relief is concerned, is by its nature equally beneficial to all the relevant members as individual claimants. What they do with any money recovered in the action is a matter for them, not the defendants. The letter of the 4th October to the claimants is not of itself binding on the claimants, let alone relevant members. If they're content their money should go to the BPI, it's a matter for them. Their wishes in that regard do not prevent the pecuniary relief being by its nature equally beneficial to all. And then the 32 follows in my judgment the claim is capable of being brought in representative capacity because the claimants and the relevant members have the same interest in the claim. The written argument counsel to the defendants emphasised there is no evidence that either the claimants or PPL or BPI have the authority to bring the proceedings on their behalf. True as a matter of fact, but irrelevant as a matter of law. The rule itself provides authority. In other words, as long as the pecuniary relief is equally beneficial to all members of the class, as we say it is in this case, a representative action for such pecuniary relief is permissible, and all members don't have to have suffered the same damage. In the piracy cases, it's obvious that some members will have more of their records pirated than others, so they'll have suffered different losses. Perhaps the most important authority in this regard is the Irish Rowan, which is at tab 18. This is an action against representative defendants of an insurance representative of members of a syndicate. And the point was taken that this was an action for damages and therefore it wasn't suitable for a representative action. Each member of the court gave a judgment, but the fullest is that of Lord Justice Staunton, and perhaps I could just take it up at 226, letter B. He cites Taff Vale, Lord Lindley, the proposition I mentioned in the beginning, and it's noteworthy that Lord Lindley, who was party to many of these early decisions, says at the end of that passage quoted that the union could be sued on behalf of themselves and other members of society, an injunction, judgment for damages could be obtained in a proper case in an action so framed. He then refers to John and Rees again, the proposition of flexibility, and then in relation to marked and night steamship, refers to a decision of Lord Denning and then says it's quite contrary to what Fletcher Moulton OJ said in marked night steamship. Thus is the law reformed. He then refers to EMI and Riley, and then to a Pan-Atlantic and Pine Top Insurance, which is a case where an action for damages was brought by members of an insurance syndicate. So it was not a claim for damages by representative claimants. Over the page at 227, just under letter A, that states of the authorities is not, in my judgment, the law that claims for debt or damages are automatically to be excluded from representative action merely because they're made by numerous plaintiffs severally or resisted by numerous defendants severally. The rule is more flexible than that, so I reject Mr. Pollock's first argument. And we say that it's clear from this case that in an appropriate case an action for damages can be brought in representative action, and that there's no requirement that the same damage is suffered by each of the representative members of the class. The judge deals with this case at 87, where he says at the end of that paragraph, I accept Mr. White's analysis of this case. The claim in that case was allowed to proceed on the basis that the court could ascertain the total amount recoverable against the class as a whole, the extent to which each class member was bound to participate. And he refers to a passage from the judgment of Sir John McGaw, 231 G, where Sir John says there may well be cases in which it would not be appropriate to allow the use of representative action procedure where there are disputes as to quantum of liability. If liability is established of persons who come into the action by representation. In such a case, the discretion allowed by the rule enables the court to forbid the continuance of representative action. In this case, there's no suggestion of an argument as to what the respective portion of the shares are. What, completely contrary to what the judge is saying, what Sir John McGaw is saying in this case is, as a matter of discretion, if there are difficulties and there are disputes about quantum, it may not be appropriate to allow the action to proceed. But he's not saying that that's as a matter of jurisdiction. He's not saying that the position is that the action can only proceed as a representative action if the position is that the total amount recoverable in the proportionate shares can be ascertained in advance. Lord Justice Purchase gives the third judgment, and again he emphasises that the flexibility of the procedure, a broad rule of, this is page 239, a broad rule of procedural convenience to be exercised with a wide but carefully used discretion, and then points out the absence of restrictions in relation to common property, which is the mistake in Templeton. And then page 244, just above letter D, referring to the authorities, they do not establish, in my judgment, contrary to the product submission, an action will not lie in appropriate cases against a representative defendant class for debt or debts, provided it's directly associated with an identified group, can themselves be defined in the framework of the contractual association established. So he's talking about a specific situation there. Now, this court in that case indicated the broadness and flexibility of the representative action procedure and how it could appropriately be used in actions for damages. The only other recent case before this court in relation to CPR 19.6 is the Emerald Supplies case, which is in the same bundle of authority. The judge refers at paragraph 88 to Sir Andrew Morritt, upheld by this court by Lord Justice Munry, that the same interest requirement was met if a defence was available to some but not all members of the class. It's 2/3 of the way down in 88. But this is not this case. It's not said that some members of the representative class, Google has a defence and others it doesn't. We say that they're all in the same position. And for the sake of completeness, let me just refer to the most recent, as far as we're aware, case dealing with CPR 19.6. It's a decision of Mr. Justice Edward Stewart, Authorities Bundle 2, page 232, in the case of...
Which tab?
I'm so sorry. It's at tab 32. My notes. The case of Rendlesham Estates and Farm. The court will see that it has a number of similarities to the Mill Harbour case. It's also a case brought in relation to development where under the Defective Premises Act. The first point to note about the case is, although the judge says that Mr. Justice Edward Stewart struck out the claim, the representative action claim, actually this was a judgment given after a trial. So there'd been a trial of the representative action claim, and the judge decided after the trial, this is paragraph 84 onwards, that it wasn't appropriate to deal with it on a representative basis. But it's important to understand the context of this case. It was a claim for damages brought by, there was a development of 171 apartments, and claims were brought by 120 of the owners. And the reason why they were seeking to bring representative proceedings was because they wanted to recover, although 70% of the owners were party to the litigation, they wanted to recover 100% of the defects to the common parts. So they wanted to bring the claim on behalf of the non-claimant leaseholders. And they sought to argue that the whole building was a single dwelling for the purposes of the Defective Premises Act. And the judge found that the damage to each individual apartment, each individual leasehold property, was case specific. So it's not surprising in those circumstances that he found that no two owners had the same interest. One finds that at paragraph 88 of his judgment. the reasons I've already given, it's unquestionably the case that proof of damage, namely unfitness of the habitation, is essentially agreed with the cause of action under the Act. On this point, I consider no two owners have the same interest in the facts of the case. The owner of apartment 1 is not concerned whether apartment 2 is fit for habitation. His claim may succeed, the owner of apartment 2 may fail, even though both of them have the same complaint about defects in relation to the common parts. And then he says this: it might be different if the complaint by the leaseholders was, for example, in respect to the defects of the central heating system supplied all apartments, with the result that during cold spells the occupiers found themselves without heating. I see it in those circumstances where the effect of the defect was the same on everyone, they'd be saying for a representative claim. We say that supports our case, because we say that the way we're putting our claim, the claim is the same for everyone. And it's understandable that on the facts of that case, some of the apartments were unfit for habitation and some were not. So to say that they had the same interests was an impossible position to maintain. He sums up his view of paragraph 270. A leaseholder can only recover damages under the Act on proof not only of defective work, but also that such work has caused or contributed to his or her apartment being unfit for habitation when the work was completed. In relation to the lead apartments, lead cases were tried in this case. Clear that while defects in the construction of the external walls are widespread, not necessarily result in every apartment being unfit for human habitation. This shows why it can't be a representative action. And we say that's entirely orthodox. That if you've got claims which are some members of the class don't have claims and others do, then it's not suitable for a representative action. But that's not the case in this case. And the defendant's submission that following the judge that we have to show that every member of the class has suffered the same damage or their share of the regular ascertainable aggregate damage is clear, although different potential defendants, different potential defences, simply has no application here. Although true it is that some members of the class may have suffered more damage, we're not claiming for that damage. We're claiming, as the court knows, a uniform sum for all claimants. So there's no different defences available. The position of all claimants is the same. They're in the same sort of position as the inhabitants of the flats in the Rendlesham estate cases would have been in relation to the central heating.
What if one of the claimants in this case, who you claim to represent, wishes to claim damages, or indeed actually does claim damages for distress as arising from the same wrong?
They could then, in substance, opt out of being members of the class. They could seek a direction that they not be represented.
What if they don't know that before the end of the limitation period? I mean,
well, the limitation period's already expired, so that's an academic question. But if it was within the limitation period, then well, we've taken, as the court may have seen from the evidence, we've taken very considerable steps to inform people of the existence of this action and to publicise what's going on. But if there were people who wanted to bring their own individualised action for damages for distress and had not, then they've had 6 years to do it, and they've not brought such an action. And as I say, had we been some years earlier, then they could at any time, and a representative action was on foot, they could at any time have sought a direction that they not be part of the represented class. Yeah, there's the 19.6 gives the court a wide discretion precisely to deal with that sort of case. There's bound to be cases of representative actions where it transpires that for whatever reason some member of the represented class is not really properly a member of that class. I think John and Rees, I haven't taken you to it, because it's really quite a long way from this case, but it was about a dispute between members of the local Labour Party, and the judge was proceeding on the basis that there were two factions, and it was perfectly possible that later it turned out there were three factions, and in that case the judge contemplated the possibility there'd be other representatives of a different subclass, but people can opt out completely if they want. Google submits in its skeleton argument that the conclusion that all members of the class have not suffered the same damage that the judge arrives at is an evaluative judgment that this court should not interfere unless the usual strict criteria are met. But actually, that's not right. The judge's conclusion, which he summarises his conclusions before he sets out his reasoning, at 82.1, the essential requirements for representative action are absent. They don't all have the same interests. CPR 19.6, and that's based on his analysis of the damages position in relation to ground one. If he's right about that, if I'm wrong, and the position is that distress is a necessary ingredient of the cause of action, distress is necessarily individualised, then I have to accept that the members can't have the same interests because they have different distress for the purposes of a damages claim. I might at some point have been able to bring a claim for declaratory relief, but those days have gone. But the judge, in truth, the judge's decision on saying damage is really simply flows directly from his conclusion on the first issue. So it's not an evaluative decision at all. But in any event, this is not a case in which Google says, in contrast to some of the other cases which have been the court has seen, it's not a case where Google says it has individualised defences to the particular. It doesn't say it has defences in relation to some individuals which are not available in relation to others. It's not the way it put its case below. It's difficult to see how it could have such individualised defences in relation to different members of the class. And there's no, on that basis, there's no reason why there are no individualised elements in this case. It all stands or falls together.
Well, one of the judge's approaches was that you're only in a position to say that by simply asserting a uniform tariff rate, which does not, he says, reflect the reality. Some will have suffered distress, others don't care twopence at all. And you have in effect self-certified by choosing to claim on a uniform rate.
Self-certification has a slightly different meaning in the context of this case, but what we have chosen to assert the rights of the members of the class on the basis of a uniform sum for all.
What I was focusing on was what the judge said in paragraph 93 of his judgment. So I don't think it's quite right to say it's all predicated on his first holding and the first part of your argument.
Well, it's predicated to this extent. He's saying that that's not a permissible way to approach the assessment of damages. So he's saying it's not permissible for us to say there should be a uniform sum either by way of damages for interference with the right or on the basis of root and part damages. It's not permissible for us to do that because really our claim for damages has to be individualised because it has to relate to the individual distress suffered by individual members of the class. If he's right about that, then I accept that there isn't
But you say
same interest.
you are entitled to plead the damage as you have done.
Yes.
It may mean that some recover less than
Yes.
otherwise might have done, but that's where you've chosen to put
Yes,
it.
exactly so.
And that is therefore the same interest.
Yes, exactly. And I said this morning. It doesn't lie in Google's mouth to say, well, you could have claimed more, and because you could have claimed more, therefore you don't have the same interest. Of course, in
Well,
once.
therefore you don't have the right to claim anything.
Yes. In once, I mean, we've done this so that we can use the representative action procedure. Of course, it's not a secret. That's why we've done it. But we've done it because only on that basis is an action maintainable. And Google has the advantage. I mean, if we'd chosen the other course, if we'd gone round and collected a huge group of individuals, I understand that there's one GLO going on at the moment where they've managed to put together a group of 100,000 claimants. Well, if we'd gone round and spent a very large sum of money putting together a group of 100,000 claimants or more, then the position would be that the costs would be hugely greater because the costs of putting together such a group would be enormous. And Google would be exposed to larger damages. Well, yes, we could have done that.
Per capita.
Well, yes, your lordship's right, and certainly larger damages per capita, but perhaps smaller damages overall. But we've done this for reasons of practicality. And my Lord Justice Davis is right in this sense. It's a choice that's been made by Mr. Lloyd as a consumer campaigner, choosing to try and assert consumer rights using this form of procedure. And yes, he could have chosen to do it in a different way, although this is the most practical and effective way that we could devise to bring this kind of action. So yes, in one sense, it is self-certification, but we've restricted the sums claimed by each individual to enable us to bring a representative action.
So you would reject the judge's criticisms of 93?
Yes.
Yeah.
The fact that some claimants would be undercompensated is if there were people who wish to be fully compensated, they would have had their own remedies, and doubtless they would take the view that being undercompensated is better than not being compensated at all.
Well, you say when he says it's a token sum or a modest one, at best, maybe.
Yes.
But that's what you've claimed, and if you're right on your first point, you're entitled to claim it for everyone, irrespective of their personal circumstances, and even if they don't care about losing their personal data.
Yes.
And the fact that it's modest or token does not mean that it's not claimable.
Yes.
You're right.
Yes. Well, that's how we put it. So we don't see anywhere there's some kind of evaluative exercise by the judge. It's the criticism is made of us by Google that this is what we're seeking to go behind an evaluative assessment by the judge, and we don't accept that. The judge has got to this by, I don't criticise him, of course. The logic of his position is clear. Once he's reached his decision on the first part, this follows as well. If the kind of claim we're making is not maintainable, then he's right.
I'm sorry to ask you a question that you probably know the answer to, and I probably should, but in Gulati, was there any assessment made of the damages given for the infringement of the right, in addition to the distress and other claims?
Well, if your lordship takes up Gulati in the bundle, very helpfully, there's tab 37.
Is it Court of Appeal?
The Court of Appeal.
Yeah.
There's a schedule to the judgment.
Yes, I'm looking at it.
Which sets out the heads of damages on which the judge made awards.
Yes. I didn't understand it, that's why I'm asking.
Well, in the my recollection is yes. Only the Fleet Street reports published the full judgment of Mr. Justice Mahan, and which we have in the bundle, and he goes through. I think that's right. He goes through claimant by claimant. Can I come back to that? I'll
Thank you.
my recollection is it is the case, but I can't immediately put my finger on the paragraph. So the next issue in this head is the judge's view that, which I've already just referred to in 82.2, even if the class is appropriately defined, then there's superable practical difficulties in ascertaining whether a given individual is a member of the class. Now, it was common ground that the class must be conceptually clear. Now, that's the Emerald Supplies point. You can't have a class which is only clarified when you get to the point of judgment. The question that the judge says, and this is paragraph 94 to 98, the insuperable practical difficulties. Now, I think it's accepted by everybody that the class is conceptually sound, so we're on to the question of workability. Well, Lady and Lords, that's dealt with in the evidence. We devoted quite a lot of analysis in the evidence to how it might be ascertained whether or not a person was part of this class. Perhaps I can just, I'm not going to go through it all, but perhaps I can just refer to it very briefly. It's in Mr.
Before you do that, just tell me what you're trying to establish from it. You're simply trying to establish that there is no insuperable practical difficulty in ascertaining if a particular individual is a member of the class.
Yes,
That's
exactly
it.
so. Yes.
And that's what's called lack of workability.
Yes, exactly so.
Right. So somebody's got to come along and say, I am John Smith, and I need to be able to tell by a clear route at all stages whether I'm a member of the class or not.
Yes, or rather the other way around. It's more likely it's coming from the other side, from the side of the representative claimant. He's ascertaining who is in the class.
But I mean, so what? I may have misunderstood this, but my understanding was that nobody is able to tell us today how many people are in your class.
Nobody is able
That
to.
doesn't matter.
Nobody is able to tell us today, in the sense that the stage of the action we're at, where no disclosure has been provided, no investigations have been done by third parties. The answer to that is yes. But what we say is Google is probably the body in the world that holds the most data about individuals going back many years. We're talking here about people who are using Apple IDs, so Apple will also hold that data. And we've done extensive analysis based on technical advice as to the practicalities.
Well, I saw a survey in the bundle.
Well,
it's all very interesting, but
no, the survey. So, I'm sorry.
can I just ask the question? What I'm concerned about is what we're legally trying to satisfy ourselves of. And I understand you say that there are not insuperable practical difficulties in ascertaining if an individual is a member of the class. No doubt you can tell me where that comes from. Maybe it comes from the rule itself, I don't know. But once you've done that, surely the second question is, can that be ascertained without reference to databases held by defendants or third parties? Because unless, if you're saying it can be ascertained in the future by getting extensive disclosure from the defendants, then at least at first sight to me it seems quite strange that that constitutes an absence of insuperable practical difficulties, because I would have thought that the rule required you to be able to identify the members of the class now.
No, indeed, that's not.
You say not.
No.
But
no.
Is there authority on
Well,
that?
I referred you to the passage from Lord Macnaghten in Bedford and Ellis, where he was
Yes, I remember.
he was singularly unimpressed by the fact that you couldn't that the people growing fruit and vegetables for sale at Covent Garden was a fluctuating group.
I know, but that didn't say that you couldn't identify who they were at any point in time, namely now.
Well,
You go along to Covent Garden and say these are the people on the stalls.
No, because there may be people who've been wrongfully dispossessed of their stalls by the Duke of Bedford and his breaching of his statutory duty. Obviously there's a bigger inquiry is to go out and find out who those people are. But it's not a requirement of the rule that the definition of the class must be workable. But it's got to be conceptually clear. But I can, as a matter of obvious common sense, if the position is it's conceptually clear but it's never going to be practically clear, you can see how the problem might arise. Mr. Campbell draws my attention to what Lord Justice Mummery has to say about this in the Emerald Supplies case, which is at bundle 1, tab 24, directly on this point, paragraph 63. We're just taking it up at 62.
Just give me a second to get that, please. Thank you.
Taking it up at 62, Lord Justice Mummery says the fundamental requirement for representative action is that those representatives have the same interest in it at all stages of the proceedings, and not just at the date of judgment at the end. It must be possible to say of any particular person whether or not they qualify for membership of the representative class of persons by virtue of having the same interest as Emerald. This does not mean, 63, that the membership of the group must remain constant and close throughout. It may indeed fluctuate. It does not have to be possible to compile a complete list when the litigation begins as to who is in the class the group represented. The problem in this case is not a class with changing membership. It's a prior question how to determine whether or not a person is a member of the representative class at all. So we don't have to be in a position to compile a complete list when the litigation starts, as long as it's conceptually clear. Now, the worst way of doing that, if I can put it that way, is asking people whether they were using an iPhone in 2011, because people may not remember, or they may misremember, or they may misrepresent. But the class definition involves the concept of the Apple ID, and having an Apple ID and using an iPhone, that information can be obtained from Apple. We could in theory have gone out and done this by way of third-party disclosure orders before the application for permission to serve out was launched. But it would be.
Well, they're under no obligation to give you that information, so how can it be practically obtainable?
Yes, we can obtain obtain orders under. I always get it wrong. The uniform procedure rules of the US courts. Is it 1782? Yeah. 1782. Enables you to get documents in aid of foreign proceedings. So we'd apply for a 1782 order against that.
Have you done that?
No, and we haven't done it precisely because it would be disproportionate to go to the expense of doing that before we're in a position to know whether we've got permission to serve out.
I mean, it's quite easy to say you can go under 1782. My limited experience of doing those things is that they are quite complicated.
Well, my lord, we've dealt with this in the evidence. Obviously, in the end, the court has to form its view as to whether that takes us anywhere. But can I just refer you to Mr. Oldmill's second statement? It's in Supplementary Bundle 1, Tab 5. And he deals with this argument, the unworkability of the compensation. He points out at 46 that the amounts of information held by Google, Apple and the mobile phone operator.
Sorry, which paragraph?
I'm so sorry, my lord, it's in paragraph 45 it begins. It's under the heading verification of membership of that class.
Yeah.
And he says that there are avenues which he's tested with his team, and then the representative claimant has received expert advice from specialist software developers, confident a reliable process of verification can be developed both automated and low cost. And then he deals with information held by Google, records held by Apple and the mobile phone operators, automated data harvesting, and then I'm not going to read it out, but can I just take the court to the summary at 71? It suggests that Apple's records accessible by.
But before you go there, can I just ask you a question? This is a question about, in relation to what's said at C, about whether or not somebody's altered their default security settings. And how there's no, there's nothing by which that could be gauged, apart presumably from what was said by the individual concerned, or is that actually technically traceable?
Yes, it's. Well, if you look at 71E,
Right.
page 93. sorry, 72 and 73.
Yes. Yes.
And the lady of the court will be aware that we're talking here about a company which processes and deals with unbelievably vast quantities of data every day on automated systems, which its business model is based on having that data and being able to use it for the purposes of its customers. And we believe, on the basis of our advice from our technical experts, that data would be available, and it would enable us to ascertain what the position was. With 71 we set out the various ways in which records will reveal who was using iPhones at the relevant time. And although this sounds, from the point of view of those of us who were brought up on pieces of paper and telephones which are connected by wires to the telephone system, all this seems terribly difficult. But here we're dealing with organisations that process, let's say, huge amounts of data in real time.
I understand that, but there ought to be an answer to the question whether or not that is something which can be traced.
Doubtless there is an answer, but at the moment we don't know it.
Right.
But the position is that the requirement of this is a matter which certainly goes to discretion, etc. And if the position was that a very large number of members of the class were impossible to ascertain, the court may say, well, look, that's just you've got a representative action which just doesn't really do the job. But our evidence at the moment is that we think we can verify the overwhelming number of members of the class. And to say at this stage, where none of this has been investigated, we're right at the outset of the action. No pleadings have been exchanged. We just don't know.
Well, that raises the next question, which is, when does this have to be determined? Because you are you asking for an order that this proceed as a representative action?
Yes.
For good and all?
No.
So just let me finish. So what happens if Google proves in the course of the action that the class cannot be identified?
Well, then the judge makes an order that it ceases to operate as a representative action. It can be, as it happened in Rendlesham Estates, where the order was made at trial, an order can be made at any time.
What does the rule say?
The rule gives the court a very broad discretion, and that's.
I mean, what I'm interested in is, what decision is this court being asked to make about the identification of the group of the class?
Well, this court isn't being asked to make an order about that at all. This court is being asked to make an order that we have permission to serve this proceeding out on Google. What test has to be satisfied may or may not be a contentious matter, whether it's arguable or whether it's a matter of law. We have a if our pleading case is correct, we have a good claim. But it's not a once and for all order. It doesn't, as it were, create a res judicata at any stage.
Do you want us to have a look at the rule?
So
The rule again.
The rule is in Authorities Bundle 1, tab 2, page 657. so the court can, 6.2, the court can direct a person may not act as a representative unless the court, 6.24, unless the court otherwise directs, and the court can otherwise direct in any way it wishes. And those cases I mentioned refer to the rule being a broad one of convenience, but circumscribed by discretion that the court can exercise to achieve the ends of justice. So if the position is, as my Lord Sir Geoffrey Ross contemplates, that it becomes apparent at an early stage that it's impossible to identify the class with any, in practice, with any particularity, then the court can make an order saying that this can no longer continue as a representative action.
The judge said it's not possible to say the numbers are insignificant. The root problem is no methodology has been proposed to ensure that individuals are excluded who fall within this category, however many they are. Paragraph 97.
Yes, well, we said that that's not right. We've proposed a methodology whereby we verify membership of the class, which is what's set out in Mr. Oldnall's second witness statement. The huge amount of work has been done on this case already in terms of investigating the possibilities. We can only go so far without obtaining disclosure from third parties, which is something that we haven't yet done because this is the necessary first stage.
Has there previously been a representative action with millions of represented parties?
No.
No.
No. I accept that.
Because those of us brought up in, what should we say, more
The olden days.
yes, think of representative actions as being on behalf of a small class of people in a club or representing the same interest or whatever. And I just wondered whether we'd slightly been left behind, and that in fact this was common practice in the internet era of people bringing representative actions in relation to digital activity, but
No.
that's not the case.
No, but I don't know if the court's had the opportunity to read Mr. Siraj's article, which is at Authorities Bundle 246. But in which is
I
referred
hated it, but didn't read it.
the point that he makes is that the class action, which is a very familiar feature of jurisprudence in the United States and also in other Commonwealth countries, actually has its origin in CPR, in the rule that became CPR 19.6, and that really, as a result of a wrong turning taken in the marked case, the rule was interpreted in far too conservative and restricted a way. As he said as the abstract says, well, the existence of class actions is commonplace throughout US and Commonwealth jurisdictions. It has often been said that such an action is unknown in English procedural law. This article, the author examines the validity of this claim that English civil procedure does not present at the present time contain a class action procedure. This was examined by reference to CPR 19.6 and its predecessors. Argued that rather than being unknown, the action originated, class actions originated from it. The English representative action now embodied in 19.6, when properly understood, is akin to Rule 23 of the US Federal Court's Rules of Procedure. English procedure law contains within it not only a class action rule, an ultimate descendant of the original class action rule, the rule from which Rule 23 class action was born. I absolutely accept that this is a a new development. This is we're seeking to use a procedure which has been traditionally used, as my lord says, in relation to unincorporated associations or insurance syndicates and so on, to provide a remedy in respect of data breaches. Now, it may be that this court will say that doesn't work. And it may be that it will be necessary that it can only, such an action can only be brought in as a result of legislation. But we say that on its true construction, if you look at 19.6 history, as long as the same interest criterion is satisfied, as long as it's beneficial to all, as long as there's not individualised features, then a class action can be brought. And that's exactly what we have in this case.
If that's right, why was it that Emerald was decided as it was?
Because Emerald, the problem in Emerald was that it was you would only know whether you had a claim when you got to judgment. So because there was the problem of passing on. So when people, it was all to do with people shipping flowers on British Airways and whether British Airways were engaged. Well, British Airways were engaged in anti-competitive practices that had been already determined. But the question was, and it wasn't clear at the beginning of the action whether people had claims on it.
Whether anybody had a claim.
Well, certainly whether many members of the representative class had claims. Some of them clearly did have claims, but some didn't. And then you get the problem of conflicts between members of the class. And obviously, one can see if people have different interests, then a representative action becomes impossible. And if some members of the class want to run one set of defences and another set of members of the class want to run other defences, then it's not going to work. But none of that exists here, we say.
I mean, there is specific process in European law for the bringing of class actions and in competition cases. But obviously that doesn't cover any of this.
Well, there's specific. One of the points that has been taken against us is that there was a proposal from the Civil Justice Council, which we have in the bundle at tab 44. The authors of which included Mr. Shiraji, for improving access to justice through collective actions, and the government didn't accept all its recommendations, but as I think we've made the point in our skeleton, that one of the bases on which the government didn't accept its representation was that CPR Rule 19.6 already provides to some extent allowing claims to be brought by those in the same interest on behalf of others in the same category. Now, an entire new regime, statutory regime for competition cases was introduced. And it's true it is that the GDPR provides that national legislatures may introduce a collective scheme for collective actions, and that hasn't been done in the UK. But those schemes and the one under the Competition Act involve third parties bringing claims on. So in other words, NGOs or representative bodies. Here, a representative action is a different procedure. It's been brought by someone who has the same interest as members of the class.
And the Consumer Rights Act 2015 only deals with competition claims.
Yes.
On an opt-out basis.
Yes. There's opt-in and opt-out claims, but
none of that helps you.
No. It's not one of. It's not within that scheme. But the first case in relation to that scheme came before this court earlier this year.
I should perhaps read from my foreword to a book called Class Actions in England and Wales, where I wrote in 2018 Since then, class actions have become a firmly entrenched and increasingly important part of the England and Wales legal system.
You don't get many class actions in Wales. Take it from me.
And I won't say that that's a very good reason for allowing this appeal, but
But you accept, I mean, to be serious for a moment, you accept that this is a unusual and, if not revolutionary, certainly innovative use of 19.6.
what I do,
Yeah.
I can't deny it. It's at the limits of the way the procedure has developed, but it's we say within the limits, and bearing in mind we're dealing with a procedure which is intended to be flexible, convenient, and to do justice, and to respond to the exigencies of the time.
And
Because
there are procedures, are there, under the Consumer Rights Act, where the class does not have to consent, in other words, where you opt out
yes,
of the group, so that the kind of process, at least, you envisage is already operating in English cases.
but in the case that Ms. Wakefield
If
was
not
in
Welsh.
no cases in Wales, the MasterCard case in this court earlier this year, under that procedure, that was where Mr. Merrick's as being the claim is representing how many people?
46 million. 46.
So slightly more ambitious than ours. So such procedures do exist, but I of course have to accept that that's specifically licensed by statute. The court may take the view this will be urged by Mr. White to say, well, if Parliament had wanted people to be able to bring these kind of actions, then it would have introduced an equivalent scheme for data breaches. As it didn't, you shouldn't be allowing this action. Well, my lord, my lady, that's the issue that the court has to decide whether to say.
The actions that were brought in the States, they were regulatory, obviously, but were there any class actions?
Yes, there was. Yes, there was a class action as well, which was settled. It's referred to somewhere in our evidence. Mr. White will know the figure, but I think it was settled for the payment of $5 million. So there were a number of regulatory actions, and there was also a civil action.
So the class action in the States was settled
Yes,
for $5 million.
I may have got that figure wrong, so I can
It's in
check.
paragraph 13 of the judge gives a summary. There was an action brought by the Attorneys General of a number of states, as well as regulatory action.
I think that was what paragraph is it?
13. Attorneys General representing 37 states.
My recollection is that there's a third action which isn't referred to by the judge, but we can check. That class action, I think, was referred to in Biddle Hall because at that stage it had been struck out at first instance in the States, and then it was restored on appeal and then settled. But
It's certainly settled by the time of Beagle Hall.
no, it was
Court
still,
of Appeal.
I think it was still continuing, but I'll let the court know. I don't have that immediately to my fingertips. So, my lady, my lord, we say that the judge was wrong on his conclusion on practicality. Was that the class is conceptually clear, we provided a full explanation as how we were going to seek to verify class membership. To say that, as the judge says, at 96, Mr. Thomas submits the point of principle is the class boundaries must be conceptually clear and this requirement is satisfied. I'm not convinced this is right. It seems to me in principle the class definition must be both conceptually sound and workable. Mr. Thomas submits those working for the representative claimant who devoted a lot of thought and work in dealing with practical difficulties. Not claiming to have a practical answer at the present time. It must be argued and submits the requirement satisfied. I do not regard this somewhat Macaubrite response as an adequate answer to the evidence, an argument for Google. Well, the position here is the evidence based on expert advice, as we say, is that ultimately a reliable process of verification can be developed, which is automated at low cost. And it wasn't right, we say, for the judge to dismiss that evidence at this stage, circumstances where there's been no investigation, no disclosure. If it turns out, as Lord Justice, as Sir Geoffrey Ross contemplated, it turns out that everything Google says is right, well, the answer is clear. The judge can simply say, sorry, as a matter of discretion, I'm not going to let this action continue. Which brings me on to discretion. Third.
Before you get there, presumably you and Mr. White had a discussion about timing. I was conscious of the fact that
We haven't.
you didn't.
I'm afraid we haven't, but the listening is for 2 days,
Yes.
and provided Mr. Tomlinson is likely to be near to finish by this evening, I shall certainly not take up more than that.
Very much.
They're very good. We've done it before. So, my lady and my lords, the third head of the third ground of appeal concerns the judge's exercise of his discretion,
Yes.
and the judge, of his own motion, said that he would exercise his discretion on his own initiative, as he says at paragraph 99, to refuse to permit the action to continue. We say that it was premature to do that at this stage, and it caused substantial prejudice because there was no evidence or submissions in relation to the matters that the judge took into account. And those were, firstly, that the main beneficiaries are the lawyers and the funders by a considerable margin, he says in 102. Well, if by that he means that the lawyers and the funders will accrue more benefit than any individual member of the class, he's of course right. But if he means that the lawyers and the funders will together recover more benefit than all members of the class, then he's wrong. But this isn't a matter that he raised at the hearing, that was raised by Google. If it had been raised, then we would have dealt with it in detail on the evidence. But if, as the judge says at paragraph 4 of his judgment, the damages is between 1 and 3 billion pounds, then the overwhelming majority of that sum would accrue to the benefit of the members of the class, not to the lawyers and the funders.
Well, I mean, you say, I suppose, that the fact that economically it's not worth the candle, or it's the costs outweigh the benefit, or any of those other things, is not something. Do you say the judge cannot properly take that into account?
The judge can take it into account if it's a matter which is properly explored in argument and evidence, but it wasn't. There was no examination of the detail of the funding agreements of how the benefit would.
So this just popped up in the judgment.
Yes, that's it. Well, I'll be corrected if I'm wrong, but I don't recollect the judge raising this with me when I made submissions.
Well, you've got extracts from the transcripts in the bundle,
Yes,
so
well,
somebody can have a look.
Doubtless we can find out. But the factual position, it's obvious that an action of this sort is going to won't be viable unless it has the benefit of a commercial funder. But that's just an inevitable feature of this kind of action, where there's a large number of people who suffered a modest loss, and the commercial funder must stand to benefit. It can't be a factor against the bringing of an action that a commercial funder will benefit, because without a commercial funder there will be no action. There will be no. These kind of actions, however they're constituted, require commercial funders to support them. It's the only way it can be done.
So you say this is an access to justice point, weighing in favour of the exercise of discretion.
Yes. Well, not quite this point. I mean, one can see, and I don't want to be unrealistic. One can see if the position is the damages are going to be trivial and the costs are going to be enormous. That's a Jamil point, and I can't say that that's not something that's properly to be taken into account. But what I can say is the judge has got to be very careful to take it into account in circumstances where it's not the subject of, the figures have not been the subject of analysis, but where it's inevitable that this kind of funding is going to be required to bring this kind of claim. It's just an absolutely necessary feature.
So it's a neutral point.
Well, at best a neutral point, but it's something that the judge, we say, shouldn't have taken into account, particularly. He wasn't being invited, as Mr. White will correct me if I'm wrong, undoubtedly, but I don't recall Mr. White inviting him to exercise his discretion against carrying out of the action because the main beneficiaries will be the funders and the lawyers, and so that the game wasn't worth the candle. And the judge also takes into account the considerable amount of court time that would be consumed. Again, it's difficult to form an assessment of that without some further analysis. If one looks at of course, court time is consumed by this case, although in comparison to cases like Rendlesham, which consumed many weeks of court time deciding on issues where the sums of damages were relatively small.
But it makes an assumption the court can't make as to whether the case will settle, whether it will fight, how much will be put into it on both sides, the attitude of the litigants. I mean, the court can't very easily. I understand the Jamil point, but this is a bit different. It's quite a big thing to say this is a competent action. He goes so far as to say, even if I'm wrong on the first
Yes.
2 points, I still would, of my own motion, decline to allow this to proceed under CPR Part 19.62, which certainly allows him a discretion, but you say not that sort of discretion.
Well, had the position, I've accepted, and I hope realistically, that we accepted here that at some stage the court would want to consider as a matter of discretion whether the action should continue. And then that these factors should be put in evidence and weighed in the balance. But none of that happened. and to do it at the outset, before anybody knows the features of the action, anybody knows what's in issue. I mean, we don't even know what the issues are in the action at the moment.
Well, because there's no defence.
Because there's no defence. We don't know how much going to be consumed by way of costs. We have no idea. We have no idea whether it will be an enormous action or a relatively modest action. So we say that the judge that's a factor which the judge shouldn't have taken into account. He then took into account that he said this is at 102. It's a striking feature of the case that 5 or 6 years since the Safari Workaround was identified and publicised, none of the millions of such individuals demonstrated any interest in coming forward to complain or identify himself as victim. That was said without any evidence at all. Again, my recollection is, and Mr. White will correct me if I'm wrong, it wasn't a point that was raised by Google. Had it been raised, then we could have pointed out the extent of the public interest in this action. In any event, it can hardly be a weighty factor, bearing in mind that anybody who thought about this would have been told, taken any kind of advice, would have been told, well, the damages are going to be modest and the costs are going to be enormous, and would likely to have said, well, thank you very much, I'm not going to do anything. The fact that, as the judge accepted, neither a GLO nor individual actions were viable means it's unsurprising that other people haven't, save for the Biddle Hall claimants, haven't brought or threatened litigation. The judge refers to that point about the judge agreeing that individual claims are not viable and GLO is impracticable is made by the judge at 103. But then he goes on to say, he draws the opposite conclusion that from the one I suggested, that this is officious litigation. So it's not a requirement of any representative action that the members, those represented, should agree to being represented. That's not the test. But to describe this as officious litigation is, with the greatest respect to the judge, going too far. This is, he doesn't. There's no question that Mr. Lloyd is a distinguished campaigner on behalf of consumers, and there's no doubts cast on his bona fides as a claimant. He's not suggesting he's doing this for any improper purposes. He's doing this because he believes that this is a proper thing to do to vindicate the interests of consumers. He may or may not be right, but to say it's officious is we say, wrong. And then he wraps that up in a kind of Jamil-esque point at 104. And then, for good measure, at 105, goes back to his point about the difficulties of ascertaining the membership of the class. With respect, drawing the wrong point from Sir Andrew Morritt's judgment in Emerald Supplies, because that's not about discretion, that's about jurisdiction. That you can't bring a representative action if you can't identify people before judgment. But I've already made submissions about workability.
Could I ask you this point, Mr. Tomlinson? In paragraph 93, you actually, this is dealing with the representative aspect. The judge stated, sorry, reading it towards the top of page 96 in the Buckle bundle, if no claimant is to be compensated, the tariff must be set the figure appropriate to the claimant who suffered the least damage. And he says, it seems to me that this would at best be a token sum, or alternatively a modest one. Do you disagree with that?
Well, I'm not sure what token means in this context, but certainly modest.
Well, doesn't that bear on the exercise of discretion? Because I also was wondering what you mean by token, and I was wondering whether, to take an example, an individual example, of assuming all the facts alleged in the particular claim are true, as of course we must, and assume also that this was a deliberate breach by Google, designed to further its own commercial interests.
Yes.
But supposing there are users, and there will be, who say, well, firstly, I don't care tuppence. In fact, I rather like it. I got a lot of adverts I wanted to see. Now, would that not be a case of nominal damages, even aside within one argument?
Well, we would say not, because this is a breach of fundamental. We say a breach of
So
fundamental.
even if someone doesn't mind, it doesn't care, in fact says, I'm glad it happened, still you say he gets damages.
Yes, yes, because this is a breach of their fundamental rights to the control over their data, and this is if Google had obtained their consent, then there would have been no breach. If after the event they say, well, I don't mind, well, obviously they have no claim for damages for distress because they don't mind, but they still have a claim for damages for interference with their rights.
And would that be a token sum?
Well, as I said, Your Lordship said, I'm not sure what a token sum means. It wouldn't be a nominal sum. It may be a modest sum. I accept that.
And, you know, the word modest for QC may be different from what you
Now.
Just you tell us what modest, what you have in mind when you say that.
Well, modest might be £50. It might be £100.
Well,
It might be that kind of
isn't that relevant to the exercise discretion?
Well,
does one allow service out of the jurisdiction where individual claims might be for £50?
But
Or you do say, you look at the 3 billion, is that what you say?
well, what I say is you have a situation where one of the largest corporations in the world, we say, has egregiously breached people's rights, and the question is, should we say, oh well, it's not the breaches aren't very bad. There's lots and lots of them, but none of them are very bad, so let's forget it. I mean, that's essentially where Google's submissions get to, but it doesn't really matter. It doesn't really matter that these rights are being breached. So that applies. That reasoning applies in almost every data breach case, because what you have is a situation where if someone hacks into the computer system of a company and takes the telephone numbers and addresses and so on of the employees, well, the damage to each individual employee is very small. But is the position that therefore the law provides no remedy? Well, Lord, if Google is right, then perhaps that is the position. But we say that where there's a wrong, there should be a remedy, and the law should adapt itself to provide for such a remedy, because this, in the old days, when people were wanting to do terrible damage to their neighbours, they went and stole their cattle or burnt down their barns or whatever. There were real world property invasions which were the law, trespass and so on, well understood. Now we're talking about, on the face of it, minor incursions into data protection rights. If they're not protected by the law, then effectively the technology companies get away with it.
I see exactly the differing starting points each you adopt. I mean, it rather reflects the differing starting points advanced by counsel in the Emerald case. As Mr. McLean, appearing for the defendant, adopted the same approach as Google here. How dare we be vexed with claims for such small amounts? And the other side was, you should be brought to account.
Yes,
It's very difficult to marry up the two settlements.
And there was a conceptual difficulty in the general supplies case, which we say doesn't exist here.
Well, maybe one of the issues we have to consider is the threshold question, because the threshold is not serious in terms of, if you're looking, for example, in relation to privacy rights, it's lower than that for a viable claim.
Yes, it's not. It's certainly not, as your ladyship knows, expressly rejected by the House of Lords in Campbell. It doesn't have to be offensive. It doesn't. It has to be. But to engage your Article 8 rights, there has to be. It has to be more than trivial. And there's obviously debate as to where that line is drawn. But I of course recognise the difficulty that Lord Justice Davis raises. But if the position is that the fact that each individual case is worth only a small amount is a bar to bringing an action, it means that collective proceedings are never brought. Because that's always the case. If
you would say, where do you draw the line?
Yes, if the case is worth £1 million per person, then you don't need collective procedure.
Yeah, but I mean, the question of drawing a line, this is not, I mean, it's not for the court to say that, I don't think, in this context, that you could say that the infringement was trivial, in which case you don't get over the threshold you were discussing this morning. But to say that because the damages are modest, that has some ramification on the right to vindicate the claim at all, is a rather more far-reaching proposition.
Yes.
Because it's not for the court to say that even £5 is de minimis or of no importance to an individual. It may be a very important sum to some individuals, even though obviously an unimportant sum to others.
My Lord, yes.
So it's hard to say as a matter of discretion, because either court say this sum is token or modest, you can't bring the claim at all. I mean, for my part, I find this discretion point quite difficult at the moment, because the judge did it on the basis that he had decided the first 2 points against you.
Yes.
But I'm sort of left wondering whether that was really the basis, or whether he was doing what judges sometimes do, which is say, I'm going to sew this up so as to tie the hands of some other court, because he obviously was influenced by the fact that he thought you had no proper claim.
Yes.
And it does indeed, some of his observations do have distinct Jamil type.
Yes.
Jamil type resonance.
Well, he refers to Jamil, of course.
I know he does.
Yes. And in his reasons for refusing permission to appeal, he says, well, even if I'm wrong on the law, I've exercised my discretion, so
He did say that, yes.
you're in trouble. And we do make that point, that the discretion is exercised against the background of him taking the view that the argument is hopeless on the first 2 points. And it's difficult to see that he would have exercised it in the same way had he taken a different view on points 1 and 2. But we do say he took matters into account that he shouldn't have taken into account, and we also say, and it's set out in my skeleton. Perhaps I don't need to repeat it orally, but he does say that there are a series of other matters which we say that he should have taken into account.
Well, you've got a list of matters.
We've got a list of paragraphs.
Three matters. You've got 4 he shouldn't, and 3 he should.
Yes, 64, 65. The fundamental rights being involved, the need for availability of a remedy, and if we're right, the substantial profit that the defendant would have made from his action. But
You make the point I just made at paragraph 67.
yes, yes. So, my lords and my lady, I think. Is there anything else I should?
Ms. Tomlinson, there's one question I meant to put to you at 1 o'clock and I didn't. So I could I put it to you now? It's coming back to the first topic.
Yes.
Is there anything you wish to say about what seems to be the fact that section 13 of the DPA basically seems to reflect the wording of Article 23 of the Charter?
It does, and I think I accepted that this morning. I make the same points in relation to Article 23 as I do to Section 13. That it can't have been the intention of the drafters, or if it was the intention, it would have been inconsistent with the fundamental rights being protected by the directive to exclude from compensation cases where you couldn't identify distinct damage, material damage or distress. Yes, I meant to refer this morning and I forgot. So perhaps I could just do it now. The court may be aware of this, but the Charter of Fundamental Rights. This is at tab bundle. Authorities bundle 1, tab 7. And under the heading Level of Protection, Article 53, nothing in this charter should be interpreted as restricting or adversely affecting human rights.
I commonly said the Charter, I meant the directive.
No. Your Lordship did, and I'll come back to that in a moment. I just wanted to refer to Article 53 because it makes clear that the Charter must be interpreted in the light of the Convention, which is a point I was making this morning, but I didn't make it good by reference to 53.
Sorry, Article 53 of what?
Guaranteed by the Convention. The meaning and scope of those rights should be the same as those laid down by the Convention, not prevent Union law from providing more extensive protection. And the two, both these provisions go to my basic point that the two, can't think of the right metaphor, but they're two halves of the same orange, as it were. They link together into one whole, the Charter and the Convention. But returning to my Lord's point, I accept that both section 13 and Article 23 of the directive contain that provision which appears to separate damage and infringement. And what I say is it can't have been the intention of the drafters of those provisions. And section 13 is just really intended to reflect Article 23. It can't have been the intention to limit claims in cases where there was an infringement but no distress or other damage. And I would construe Article 23 in exactly the same way as I construe Section 13. In other words, that there would be an entitlement to compensation in respect of the damage which resulted from a non-trivial contravention of the requirements of the Act or the Directive. Because without that construction, it means that you remove the right to compensation from children, from those who never get to know that there's been a contravention.
And you wouldn't accept that Articles 22, 23 and 24 of the directive incorporate a degree of, I'll say, subsidiarity, leaving it to the member states to decide how to go about it.
Well, the precise assessment of damages, and I think we've been over this point before, the precise assessment of damages is of course a matter for national law, the rules in relation to damages, but the judicial remedies, liabilities and sanctions, which are governed by chapter 3 of the directive, are matters which should form part of national law, and indeed do.
So thank you very much. I'm sorry, I had meant to raise something with you this morning, and
No, it's...
Mr. Tomlinson, I wonder if you might deal with my Gulati question tonight.
Yes, but perhaps I may just have the opportunity to finish briefly tomorrow morning.
Mr. White looks sanguine, so
He always...
we'll sit.
Mr. Tomlinson, I do a lot of cases together. I trust him to leave me enough.
I put the word briefly down in my book.
You're sitting in at 10:30 tomorrow.
Bye.